Morning again to you all. The court is going to call the Galloway matter, 26T 239. Ms. Galloway, thank you for coming on up to the lectern. Ms. Pretz, if you'd like to enter your appearance.
Caitlin Peretz for the people.
Thank you. And so we are scheduled this morning for the first arraignment in the division. Ms. Galloway, you've had 2 advisements in this courtroom, and now today you are scheduled for arraignment. Ms. Pretz, I understand that you've had an opportunity to speak with Ms. Galloway. Is there a meeting of the minds regarding how to proceed?
No, Your Honor. The offer in this case is for if she has proof of a license and registration, then we would dismiss the case. In the alternative, she could plead to the original count 1 with a fine. But Your Honor, my understanding is that Ms. Galloway has not been able to get the documents and does not wish to enter a plea of guilty.
All right. So Ms. Galloway, what the court will do for you then is enter a plea of not guilty on your behalf. Don't interrupt.
Yeah.
Just a minute. Let me finish what I'm going to say, and then you'll have an opportunity to talk, okay? So because you haven't reached an agreement, pursuant to Colorado Revised Statute 167208, the court will enter a plea of not guilty for you. That way we can move the case forward. Then what the court will do is set a trial to the court. I'll give you those dates in a moment, but it seems that you wish to say something to me before I give you those dates, and I'd be happy to give you that opportunity.
Yes, I'm Zoe G. Galloway, and I'm here on special appearance, not general appearance, and I reserve all rights with explicit reservation without prejudice.
Thank you. So if you could stop right there, you actually have to appear on your own behalf. You can't make a special appearance.
Okay, as the record reflect, I am making a special appearance.
So just a moment. The record will not allow for that. You may say that, but you must appear as Ms. Galloway, a human being, not a special appearance. The law does not recognize a special appearance.
Okay.
You may continue.
Honorable Judge, does the court record reflect that I'm here on special appearance and that I have accepted and returned all offers of the court, the clerk, the prosecutor, and police officer for full settlement and closure of this matter, and this creates a liability upon this court to settle this matter immediately?
Okay, thank you. So your trial to the court date will be November 12th. Ms. Pretz, will 2 hours suffice?
Yes, Your Honor.
All right. So the trial to the court will be November 12th at 10 a.m. We'll set you for a motions hearing on October 8th at 3 p.m. The deadline for any constitutional or testimonial motions will be September 17th, and the Rule 16 deadline will be October 8th. Ms. Galloway, I'm going to write all of that down for you, all those deadlines, and then I'm going to give you some resources to help you prepare for your trial to the court. We'll give you a brochure about how to present evidence in court. It has the information for our self-help center. We'll also give you a flyer for a free legal clinic through the Boulder County Bar Association. If you'd like to resume your seat, I'll write all of this down for you, and Mr. Lammers will call you when it's ready.
Does the record reflect that I plead equity?
Thank you. The law does not recognize such a plea.
I accept her dishonor. Does the record
you.
reflect that the judge is obfuscating the record by entering a false plea on behalf of the defendant, and I do indeed plead equity?
Okay, thank you. Ms. Galloway, your hearing has come to a conclusion. You may have a seat, and in a moment, Mr. Lammers will call you up when the order is ready.
I accept any future hearings you have on this matter.
James S. Bell.
Yes, Your Honor.
Mr. Bell, looks like you are here on a new charge. Did you watch the advisement of rights video?
Yes, Your Honor, I did.
Okay. Your new charge is on complaint warrant 2026-1072-1507. It is a 4th-degree contempt charge for violating a judicial protective order or no contact with victim order or pretrial services home detention order. For that charge, the state has filed a motion to have you detained pre-trial. You also have 2 violations of monitoring that were filed in case numbers OCN 26967-001 and OCN 262054-001, for which you were previously released on pretrial monitoring level 3. The state has filed a motion to revoke your release on those 2 cases as well. That means you will be held until at least Friday, when you will appear for a hearing before a Superior Court judge to determine if you should be released on these charges, if so, on what conditions, or continue to be detained in jail pending the resolution of your charges. Mr. Lindsay, anything further from the state?
No, Judge, nothing further. Thank you.
Mr. Cook?
Nothing, Judge.
All right, sir, unless you retain the services of a private attorney, the public defender's office who has represented you today will continue to represent you for the purposes of those hearings on Friday, and an attorney will be in to speak with you to prepare you prior to that date. Do you have any questions at this time?
Yes, I'm not understanding how I didn't comply with the pretrial intervention services when I've been consistently checking in. Also, I'm not sure how I picked up a new charge other than me walking in and handing in paperwork. I also am not sure.
Sir,
So I need you to hold on a second. I'm also not sure why my.
I would advise you not to continue.
My God-given rights and my rights period keep consistently being violated, and anytime I even try to mention these things, I end up getting more charges. I just don't understand it or comprehend it. I didn't hurt anybody. I didn't go around and do anything illegal. All I did was walk in the front door, present an official notice, and turn around and walk out, and then I got arrested as I showed up to court. So I'm like mind boggled on the people who are supposed to protect and serve my community on why they keep.
The courtroom has one powerful message: legal rights are real, but invented rules don't override them. Did this equity strategy just backfire spectacularly?
Reiterate this, the more individuals keep trying to tell me that I need to be silent for yous breaking the law, for yous not upholding. Yous are allowing individuals who commit acts of treason, espionage, and pedophilia to roam rampant throughout this government. And this is one of the main reasons why I'm running traditionally. So whether you see me here or you see me outside of here, get ready, because I'm going to keep showing up. And it's not a threat. I'm just a humble dad who wants things done properly for my community. And I'm in the community every day, working for thousands of people out in my community. This is a joke, and I'm sorry to say so. I respect all of you and what you do, although if you're not listening to all the characteristics, you don't get the full end of the story. Y'all have a great day. I'll see you Friday.
Sir, your attorney will be in to speak with you to prepare you for your hearing.
This hearing began as a routine arraignment, but it quickly became a disagreement over how the defendant wanted the court to handle her case. Ms. Galloway rejected the prosecution's offer. That offer would have allowed the case to be dismissed if she could provide proof of a license and registration. She could also have accepted a plea to the original charge with a fine. Instead, she refused to plead guilty and began challenging the way the court was handling her case. Galloway said she was appearing under a special appearance and wanted to reserve all of her rights. The judge immediately explained that the court did not recognize that type of appearance and that Galloway had to appear on her own behalf. The judge then entered a not guilty plea for her so the case could continue. The court set a motions hearing for October 8th and a trial for November 12th. The judge also gave Galloway written information about presenting evidence, along with resources for legal assistance. Things became more heated when Galloway claimed she was pleading equity and accused the judge of entering a false plea. The judge rejected that argument and ended the hearing. The transcript then moved to James Bell, who was facing a new contempt charge along with alleged violations of pretrial monitoring. Bell questioned how he had violated the conditions and strongly argued that his rights had been ignored. The court did not resolve those arguments during this hearing. Instead, Bell was told that his attorney would prepare him for the next hearing. So, what do you think? Did the judges handle these situations the right way?
She's pushing an equity theory, but courtroom labels don't erase established law. A judge must apply legal rules, not personal interpretations. Will she back down?